Hello and welcome to Legal Week Risk Management Q&A in association with Nabarro. Joining me in the studio is Tom Dane, a Senior Associate in Dispute Resolution at Nabarro. And today we're going to talk about risks surrounding the application of privilege. Tom.
Hi.
Why is it important that businesses need to know about privilege?
Well, privilege is a basic common law and human right which protects the confidentiality of certain communications between a client and their lawyer for the purposes of giving or receiving legal advice. In the context of legal disputes, it also extends to protect communications not only between a client and their lawyer but also a third party such as a witness where it's made for the dominant purpose of those legal proceedings. It's a right which has been recognised in English common law for a number of centuries now. The rationale behind the rule is really to encourage full and frank exchanges between a client and their lawyer, safe in the knowledge that whatever is said to the lawyer and whatever advice is given back will not be disclosed to a third party without the client's consent. So you can see it's important as a fundamental rule of law, but also in practical terms it's got real importance in terms of privileged communications not necessarily being disclosed to third parties. So you've got non-disclosure to a court, whether that's civil or criminal, non-disclosure to an opposing party in litigation, and quite importantly these days, non-disclosure in the context of certain regulatory investigations. It's probably worth noting that not all communications between clients and lawyers will be top secret. There may well be an element of day-to-day routine business advice which a client wouldn't mind being disclosed to a third party if they needed to. And indeed, in the context of regulatory investigations, clients will often give voluntary disclosure. However, there will almost certainly be more sensitive issues on which legal advice is being sought where they certainly won't want that advice to be disclosed. And that's why it's important that businesses are aware of the rules and how they apply so that privilege can be claimed in appropriate circumstances.
And what are the different types of privilege?
Well, the main different types of privilege which will apply in day-to-day business work will be firstly legal advice privilege and secondly litigation privilege. So dealing first with legal advice privilege, that's confidential communications between a client on the one hand, a lawyer on the other for the purposes of giving or receiving legal advice. So that's the privilege that will apply in most non-contentious situations of day-to-day business advice, whether it's corporate advice, tax advice, property advice. A couple of points to note on that definition. Firstly, lawyer is given quite a wide definition.
Right.
So lawyer in that situation will encompass anyone in private practice, whether it's an associate, a partner, even a trainee, provided they're being suitably supervised in the advice that they're providing. It also extends to in-house counsel, with a slight exception for certain European law situations. Yep. And it also, as you'd expect, extends to barristers. And that should be contrasted with the much more narrow definition which is given to client. Now, in a large organisation, client will not necessarily mean all employees within that organisation. And it's quite an important point to note because it's only those who are tasked with seeking or receiving legal advice, so perhaps someone on a particular committee who might be, in quotes, the client for the purposes of the exchanges with the lawyer. And that is an important practical to note, both in terms of being able to have privileged communications because it only comes from the client to the lawyer, and more importantly, not losing privilege because if you circulate it much more widely, even within a client organisation, privilege could be lost. So that's legal advice privilege. The second head of privilege is litigation privilege, and that applies in the context of legal proceedings which have either commenced or are reasonably anticipated. And that protects confidential communications not only between the lawyer and the client, but also the lawyer, client and third party, such as a witness. And so you can already see that for the purposes of that definition, the test is much wider. It extends to communications with third parties.
Right. And what are the main areas of risks for businesses when looking at the issue of privilege?
Well, really, these fall into two parts. On the one hand, the main risk is ensuring that where a business wants a communication document to be privileged, it ensures it meets the test for doing so. And you can see that in the context of a non-contentious issue, so you haven't got legal proceedings, you haven't got the wider litigation head of privilege, you're dealing with a much more narrow legal advice privilege. There has to be a communication between the client and the lawyer. And a problem area that sometimes arises is that lower down the chain at a commercial level, documents are created, maybe a fact-finding report at that level, which is then circulated internally at a commercial level. And there's no legal involvement, despite the fact that maybe that document at a future date may be provided for the purposes of providing legal advice. The problem is that at the stage it's created, or at the stage it's communicated at a commercial level, it's not privileged. So that's risk area one. Risk area two is really, once you've got a privileged document, ensuring that privilege is maintained over that. And privilege can be lost if an inadvertent waiver of privilege is made. So really that means that the confidentiality in the communication is lost by distributing it widely to a third party who's not the client, or, given the narrow definition of client, even distributing it widely internally in an organisation. And in those situations, the confidentiality can be lost and privilege can be inadvertently waived.
Right, so given that there are risks that could have quite major consequences, what are the practical tips to avoiding making those pitfalls?
Sure. Okay, well, I mean, there's a number of basic steps which organisations should probably get in good habits of practising just in day-to-day business work. So first is to label communications or documents that are intended to be privileged as being privileged and confidential. Now, the label itself won't be determinative as to whether privilege will apply, but it certainly gives a good steer as to what's intended, and it should ring alarm bells with people once they receive that document not to send it on widely, either internally or externally. A number of other steps: you might want to separate out legal advice on a separate file so it's clearly kept away from commercial documents, so that if a regulator does come and ask for a file of papers or on a particular area, you know that your privileged advice is kept separately. On a similar vein, you can separate out issues from particular documents. So a board report, which might include elements of privileged advice but also commercial issues, think about keeping those two separated out in separate documents, one clearly headed privileged and confidential. But really, I think probably the best tip is for people both in-house and at a commercial level to have a basic understanding of the issues surrounding privilege, so that when certain situations arise on a day-to-day business level, they know that, okay, that triggers something which we need to think carefully about this. Do we want to ensure that it's privileged and take appropriate steps tailored to the particular business and the circumstances to ensure that privilege applies? Right, excellent. And there have been some important legal developments. There's the Nobel case, and there's also been an important case involving accountants. Can you tell us a bit about that? Sure. I mean, they're both recent decisions of earlier this year, and both have received quite widespread publication in the legal press, certainly. I think the important point to note from both of these decisions is that neither have changed the existing state of the law. Right. So, dealing first with the European Court of Justice decision in Nobel, I think as most people in the legal profession will know, what that decision did was confirm that legal professional privilege cannot be claimed by in-house lawyers in the narrow sphere of European competition investigation. So in order for privilege to be claimed, it has to be advice and communications between the client and an external lawyer rather than the internal legally qualified employee of that company. Right. But that's been the position since a European Court decision in 1982. So although Nobel has hit the headlines at the various stages in its progression through the courts, it hasn't actually changed what the law has always been, certainly for the last 30 years. The second decision was the Prudential Court of Appeal decision, which came out a couple of months ago. And again, that hasn't changed the status of the law. What the decision said was that accountants cannot claim privilege even if they're providing advice on a discrete area of tax law. Yeah. And that's really been the position for hundreds of years under English law. Privilege can only be claimed between a client and a lawyer, and it doesn't extend to advice given by other professions. So, I think that they're important decisions in the fact of maintaining and confirming what the state of the law is, but in terms of changing it, I don't think that we're going to see any major developments in the coming years. Great. Well, thanks very much, Tom. And thank you very much for watching Legal Week Risk Management Q&A in association with Nabarro.